Welcome. It's Mal from the Money Study bringing you another episode of the Ultimate PSS Education Series, and we're indeed up to number 39, PSS and death. Not a wonderful topic, but obviously something we need to have a look at and see how it impacts on the members. Before we do, there's our normal disclaimer. There's facts and figures in this session, there's information, but we are not providing you with advice. Okay, with the PSS, if you are a contributing member, so you're basically working away, and on your statement on page 3, it will actually tell you what your death benefit would be there. And we can see in this particular case that this person's got a death benefit there of around about $60,000 would go to their partner as a pension. And there's also this extra $37,000 there, which is a lump of money. And the reason that lump of money would be there because this person has actually got a post-95 transfer amount. So they've got their pension money and they've also got a lump of money. Alternatively, the partner could indeed decide to choose and could just take the $1 million there, $1,012,000 as a lump of money. The member indeed has the member's dead. The partner, the spouse, indeed has a right to choose between those two things. Now it says in the fine print under the numbers there, an eligible spouse can take it as a full lump of money and so forth. The key word there is being an eligible partner. And this can cause a little bit of concern and issues and so forth. But I've put a bit of information here to explain really what is classified as a partner. Because on your death, your partner will receive a PSS benefit provided that it's decided that they have a marital or couple relationship with you at the time of your death. So you obviously don't have to be married here. It is married de facto same sex. A marital or couple relationship exists where two people have ordinarily lived together as husband and wife or partners who are in a permanent and bona fide domestic relationship for a continuous period of at least 3 years at the date of death. So that's, that sort of spells it out. And this whole business of living together is one of the key factors that they look at as whether there's a relationship or not. And it says there, if the relationship had existed for less than 3 continuous years at the member or pensioner's death, eligibility can still be determined where CSC is satisfied that the person ordinarily lived with the member or pensioner as husband and wife or partners. So a bit of discretion there coming from the CSC. And my understanding is that I went looking for this information, but I couldn't find it quickly, but I will dig deeper and let you know. My understanding is that if there was if someone was actually receiving a pension, they died, and the partner had only been living with them for 2 years, my understanding is they actually get 2/3 of the normal benefit. And if they live with them for 1 year, they get 1/3 of the normal benefit. Now that could be wrong, but I will certainly verify that and get back to the people later on. And when I do know it, I'll update this presentation, but I'd rather get it out there to you as soon as I can now. If in making their assessment of eligibility, the following factors may be considered. So financial dependence, so the partner is actually relying on the member for money, whether they were legally married, it's pretty obvious, whether you're in a registered relationship, whether you and your partner relationship had a child, be it your own or be it adopted, under the meaning of the Family Law Act. So if you've got a kid together, that certainly does help, as you would certainly hope. Joint ownership of property, so if you've got a property together, and any other relevant evidence, so probably having shared bank accounts or other ownership of other things, and so it goes on. So look, if your situation is a little bit doubtful or unusual, look, I always suggest to people, send off some information to PSS now before you're dead, to basically they can have it on file to suggest that yes, we are in a relationship, but this is the scenario due to X, Y, and Z. Where a person previously had a marital or couple relationship. So this could be your ex, and I've had a few questions on this already. But the relationship finished before the date of death. A spouse benefit may still be payable if, at the time of the deceased person's death, the spouse was legally married to the deceased pension. So even though they'd split up, they were basically, still married. They were wholly or substantially dependent on them for money. And of course, a person can still be considered to be living with another person on a permanent and bona fide domestic basis, where it's determined that the person would have been living with them, except for some sort of thing like illness or perhaps in jail or something like that. So as you can see, there's a lot of things here that, as I say, can be discretion. I had an interesting one where the couple had actually broken up, but were still actually living in the same house, and but one of the partners had indicated that they were indeed separate. So this is the sort of information, depending on which way you want it to go, you take that information and you give it to PSS, so they know when it comes to doing. They don't just say, oh yeah, they're living together, so therefore the couple, this is where the money's going to go to, and so it goes on. It's not completely black and white, that is for sure. The death cover. Now, the death cover you've got, if you're a contributing member there, is based on the same formula as retirement, but it's calculated on a future value. So it's effectively saying what you would have got had you been able to keep on working through to 60 based on what you are currently contributing. So perhaps if you start to think, this condition I've got's not too good, you might want to ramp up your contributions immediately to 10% if you're not, because that's what they base it on. But there is no wage growth in that calculation, is my understanding. You can indeed apply for extra cover, this thing called ADIC, Additional Death and Invalidity Cover. I'm going to do a presentation on that as a separate item. And the amount of cover you can get will vary depending from person to person. It literally brings up your benefit as if your ABM was a maximum of 10 at the age of 60 there. So depending on how big your ABM is, will depend on how much ADIC you can indeed get. But, it could be a situation that you might have started late in the PSS, so you don't have that much in the PSS. You might still have 5 kids at home and a big mortgage, so your death benefit is just not sufficient. A lot of people don't look at this, that they have insufficient insurance. So, if you've got other insurances, you might want to compare the premiums that PSS are offering you for the amount of insurance they will give you, because effectively with ADIC, your employer pays for half of the premium. So that's nice. You've increased your insurances, but your premium's only really costing you half there. Now, I think the downside of the PSS is that you don't have any benefits there for income protection. Unlike the PSS AP and all the other normal industry super funds, they provide an income protection. There is no income protection available for the PSS. Having said that, there is a thing called partial invalidity, which I will certainly be doing a presentation on that, a video coming up in the next few days or so, hopefully on that. If you can always go to an insurance company to get income protection, to plug any holes if you believe that's what you do indeed need. Now, if however, and of course a preserved member, effectively there are no insurances. If you are indeed on a pension already, and then you pass away, yes, then the pension goes to the partner. The partner doesn't have a choice. The partner cannot choose a lump of money if the member was already on a pension. That's been selected, a pension for life. Therefore, the partner gets the pension for life and they cannot cash it in. And so again, it's married de facto same sex, all the rules of being an eligible partner there. It also includes dependent children. If they're 18 and under, they are a dependent child. If they're 25 and under, but in full-time studies, they're also classified as a dependent child. The pension is paid for the lifetime of the partner, and is indexed for the lifetime of the partner. So you could have a partner literally who's 20 years of age, and this thing could pay till they're 120. If the partner was over 60, sorry, if the member was over 60, if the member was over 60 and receiving the 10% tax offset that they would because they were over 60, then the spouse gets that offset irrespective of how old they are. So, if the the spouse was, say, only 40, they would indeed get the 10% tax offset on the pension if their partner, the member, had indeed been over 60 at the time of the death. The pension is not incomes tested, so the partner could indeed have more than one pension. They might have already had, unfortunately, passing of another partner who was in the PSS or CSS or something similar. They can have their own pensions. They could be on $1 million income. This pension is paid irrelevant to any of their actual financial situation there. What do they actually get? So the spouse gets 67% of the pensioner. So if the pensioner had a pension there in this example of 101,601, then the spouse would get a 68,073. So, and this is based on our example we've been carrying through all the way through this thing. So you can sort of see, it's 68,000 effectively is the Australian standard just about for a comfortable lifestyle and retirement. So the spouse is in theory left in an okay sort of situation here. For every extra child, an extra 11% for every dependent child. So if we had 3 dependent children, then effectively they would get the full pension that the pensioner was on. There is indeed a opportunity here if you would like to choose the second option, which is a 93% pensioner. So, and this is done at the time of selecting the pension, not at the time of their death. This is basically saying that when the pensioner took their pension in the first place, they elected to take a 93% option, meaning they're only going to get paid 94,000 instead of 101 while they were alive, knowing that when they passed away, their partner would get the bigger pension, as if not a very popular option. I can let you know that. But obviously, look, there's obviously very serious reasons why that would be a good idea. The member might indeed have poor health. Their life expectancy may be short. Their partner might be 30 years younger, in which case, it makes a hell of a lot of sense for them to take the smaller pension so that indeed the partner and the family effectively get a better income for a longer period of time there. So quite sensible under certain circumstances. But you can see there, if the member, the pensioner, gets 93%, then the spouse gets 85%. And then they get that extra 11% or so, or actually it looks like 12% for the children. And this is basically, they end up with over 108% of the pensioner's value. And those percentage are of the reduced pension. So that's basically what they get. But of course, there's all sorts of other issues we still need to consider. Where a spouse who is receiving a pension then remarries, so they're receiving their first partner's died, they're receiving their pension, they remarry or starts a new relationship, the pension continues on. So doesn't stop literally because they have remarried, but of course that pension does not revert to their new spouse when they pass away. Okay, so this thing's not just handed down from spouse to spouse to spouse to spouse. An associate pensioner, that's one that where you've gone through a marriage split, and the partner who was not a member receives a pension from the PSS because of the marriage split. Anyone who's got an associate membership, they're on a pension. If they die, no, the value does not then pass on to the spouse or children on their death. So a bit different for it if you've got an associate membership. I will be talking about associate memberships and family law in future sessions there. Now, orphan benefits basically. So, yep, if the partner, the spouse, has already passed away, and so we've only just left with dependent children. So there are lump sum benefits payable to children. So orphans' benefits are payable to eligible children if you die without an eligible spouse. We're a contributing member who is not a limited benefits member. A limited benefits member is a member who had health issues while they're at work, and their death benefits and invalidity benefits were limited. I might even do a session on that one as well. But if therefore we're a contributing member dies and an orphan's pension is payable, the pension is paid up to those ages of 18 and up to 25, while the orphan is a full-time student. This means that the pension may only be paid for a short period of time. But a lump sum benefit may also be payable, so they'd be getting the pension if the total amount of the pension expected to be paid is less than the lump sum value of the benefit that would have been paid to this deceased had he or she become entitled to invalidity benefits. So they're looking at what the pensioner would have got as invalidity, and if that amount of money hadn't actually gone to the orphan, then there is a lump sum payable. Okay, so a lump sum benefit is payable in lieu of a pension to or on behalf of the orphans following the death of the limited benefits member. So if you did indeed have health issues there, then just a lump sum benefit is payable. What does an orphan get? Different than a spouse. So if there was one orphan, they'd get 45% of the member's pension entitlement, 2, 80%, 3, 90%, and if there's 4 or more, the full pension is paid. So yeah, obviously, it depends on if these children are actually, if what's the word I'm looking for? If they are under 16, I'm guessing they would need what's the word I'm looking for? Gosh, they wouldn't be old enough to look after, be responsible. They'd be in a trust. That's the word I'm trying to look for. This money would probably be held by some sort of a trust, or the person who's looking at the guardian that is looking after the children where that money would actually go to. So there could be a bit of illegal ramifications around orphans' pensions. Now, I get this a lot where, what happens, of course, if we don't have, partners, we don't have children and so forth. There's always a minimum benefit payable. The minimum benefit that must be paid in respect of a PSS member varies depending on whether the member retired on age, involuntary grounds, or on invalidity grounds. So depending on what sort of, how you went, determines on what sort of money should indeed flow to your estate and so forth if you indeed die. So if you retired on age or involuntary grounds, or were a preserved member before your pension became payable, the minimum benefit is the total of your member contributions and fund earnings and the minimum employer benefit payable under the super guarantee legislation. Now, what does all that mean? It basically means that what they look at is they're sort of saying, we'll pay you, if you died on retirement, then under normal circumstances, you weren't in the PSS, then what would happen? You would be in someone like AMP or whatever, and therefore any money that when you died, all of it would effectively go to your estate. And so what this rule says, it's really making sure that you're no worse off by being in the PSS, because what they've included there is the member contributions, so that's what you would have been putting into your AMP. They've included the fund earnings, which is what you would have got had you been in AMP, and the minimum employer benefit payable under the super guarantee legislation. So this is the 9.5%, 10, 11%, so forth, whatever the rate has been over the years of what the employer has been paying into the super fund. So it's like they've looked at your PSS as being invested with all the member and employer contributions, getting the earnings, and therefore that's the pot of money for the death. It's meaning that if there is no spouse or no child, no dependent, so therefore the estate is no worse off. So it literally means that if you're draining this pot of money with your pension. So if over time you have drained more than that pot of money, then there'll be nothing left to go to the estate. And quite frankly, why should there be? I get people saying, you mean to say if I die at 85, my kids get nothing? Of course not. Of course not. Because literally you have drained the pot. There is nothing left to go. If your kids are 60 and you're dying at 85, and in the meantime you've spent 3 times your lump of money, remembering that your pension, even at 55, is a 12th. So every 12 years you've been paid your lump of money. So, by 67, you've already been paid your lump of money. So why on earth should there be more money to be going to estate if you've already received it? If you've got a spouse, yes, it just keeps on paying, and so it goes on. But this to me, this thing here, I think it's quite fair. You might argue the point with me, but that's okay. If you retired on invalidity grounds, the minimum benefit is a little bit different. It's the benefit accrual up to the date of the invalidity retirement. So it doesn't include any amount in respect of the benefit that would have accrued had you continued working, because obviously, you weren't able to work. So therefore, why should your estate indeed, benefit from something you never did in the first place? And where no further pension is payable, so you die and no spouse and or children pensions are payable, or your spouse subsequently dies and no children's benefit is payable, the minimum benefit payable is compared to the total benefits paid out as pension and lump sum, and any minimum benefit balance is paid to your estate. So there it is. They look at that amount that is in your pot, they take off what you've already spent, any money left over goes to your estate. So it does not just disappear. Now, if you've used it up, there's nothing left, that's different. But if you die early and you don't have any kids, the money does go to your estate. I get far too many people who will basically take a lump of money because they're worried about dying and their estate's going to get nothing. I mean, is that really sensible in the regard that, you've given up your benefit, your lifestyle in retirement because you're worried about dying? Now, so obviously, yes, if you know your life expectancy is poor, then yep, take the lump sum, enjoy it. I don't, obviously there are different scenarios here, but for the bulk of you listening to this, what's most likely to happen is you'll live to your life expectancy, which is vastly longer than what this benefit is worth. So yep, a lot of things to think about there. But I do say if you're in a really odd situation, look, just contact PSS indeed to let them know what your scenario is. We are here to help you understand this a little bit better. It's not easy, but if you've got concerns of how you might want to consider it, it could be just the situation that you literally, if you're worried about all of this, can you afford indeed to take some of your pension money and buy a death-only policy? So that the PSS might go in one direction or run out for non-dependents, but you've got a death cover that you literally pays a lump of money on your death from some standalone insurance company. All sorts of other ways of considering it. You might have been salary sacrificing into another super fund. In the other super fund, you keep that as an accumulated account with insurances, depending on what age they will let you do it up to, and so it goes on. There's other things that we can think of to ensure that the money you want in retirement goes where you want it to on your passing. Okay, we'll talk about some of these other things as we go forward and we start talking about invalidity in future sessions.